Good evening, ladies and gentlemen. I'm Michael Rossi, Chairman of the Clinton Planning and Zoning Commission. I would like to call this special meeting and public hearing to order. Will the clerk please call the roll?
Michael Rossi,
Here.
Bo Clark,
Here.
Ellen Dahlgren,
I'm here.
Eddie Alvarino,
Here.
Mike Florio cannot be here, Shinzia Lettieri,
Here.
Jay Mandel,
Here.
Zach Plord,
Here.
Hey.
Dylan Walter,
Here.
Andrew Randy, Susan Marcus,
Here.
Brian Pellegrini.
Okay, I would like to see Susan for Mike Florio. We have a forum. So we're good to go. My comments tonight, I want to start by noting that we will not be opening PZC 26-14 tonight. That is the parking management district. Because it requires a map change. And there's been some delay in notifying all 1,300 people in the proposed area of the change. So we cannot open we cannot open it until we have made sure we've taken care of that legal issue. Okay. With that, we'll move on to the public hearing. And Ellen, can you read the notice of public hearing, please?
Okay, in accordance with our regulations, I'm reading the entire legal notice of public hearing as published, even though it includes
Yeah.
something that is since.
Right. You need to read the whole thing.
Yeah, I know. I'm just saying that to our vast audience. The Clinton Planning and Zoning Commission, excuse me, the Town of Clinton Planning and Zoning Commission will hold a special meeting and public hearing on Monday, June 22nd, 2026 at 7 p.m. to consider the following. PZC 26-13 Planning and Zoning Commission sponsored text amendment to the Clinton zoning regulations for sections 3, 10, 12.3, 23, 27.2. Addition of a new section 37 for middle housing unquote to comply with the requirements and restrictions of Public Act 25-1. PZC 26-14 Planning and Zoning Commission sponsored zoning map amendment and associated zoning regulations text amendments to sections 21 and 33 and the addition of a new section 24 for parking management district unquote and 33.12 for parking needs assessment unquote to comply with parking related requirements and restrictions of Public Act 25-1. At said hearing, all persons will have the right to be heard. The applications and correspondence are available for public inspection on the town's website. Anyone requiring special accommodation to participate in the public hearing should contact the land use office at 860-669-6133. Michael Rossi, Chairman, Town of Clinton Planning and Zoning Commission.
Thank you. I would like to note, Zach had to check out at 7:03. He's not back yet. We'll notice the time when he comes back. Okay, for the public hearing on 26-13, this is the middle housing portion of the regulations. Abby, would you please give everyone a summary of what we're doing?
Absolutely. So, as folks know, this is an amendment to the zoning regulations. So this is only the subject of PZC 26-13, the text amendments to be prepared for the requirements that come into effect on July 1st, that flowed from Public Act 25-1. That act was adopted and signed by the governor in November of 25, and towns have been working together, and we received some support services from the Lower Connecticut River Valley Council of Governments to create these text amendments. So we'll give a quick overview. I'm not going to put all of the text in this presentation, but we can pull up the IMEG memo that has all of that text if there's pieces that we want to go through. So we'll talk about why the regulation change is necessary, what the proposed regulation changes are, and then kind of what our next steps look like. So like I said, the regulations for, the act is an act concerning housing growth. It goes into effect July 1st. And fundamentally, our regulations are not compliant with the requirements related to middle housing in the act. And so the reason we're here tonight is to make sure that our regulations are compliant. So one of the important things to think about is what is middle housing, because it's not a term that already exists in our zoning regulations. So essentially, basically, the act requires that transit, community middle housing, or mixed-use developments have to be allowed on any lot that is zoned for commercial or mixed-use development, subject only to summary review. Transit community middle housing is defined as a residential building containing not less than 2 dwelling units, but not more than 9 such units, including but not limited to townhouses, duplexes, triplexes, perfect sixes, and cottage clusters. So these are the housing types and the number of units that have to be allowed by summary review. And summary review is an approval process that's comparable to site plan application. It prohibits us from holding a public hearing about these particular applications, but does include a public health safety component that is a little bit more than what's in site plan. So there's one small distinction there, but there is no public hearing component to these proposals when they come in. Some of the issues that may arise if we don't adopt these regulations, it would be questionable as to whether the commission could impose design standards or place conditions on middle housing development. So if you wanted specific pieces like where parking can occur or what landscaping is required, those things may not be permissible if we don't have regulations that spell them out because of the summary review process. The amendments also clarify that the commission's site plan review process is the summary review process, so there's not challenges as to whether or not it should be just a zoning approval or there's something missing in our rights about this. The other piece is that the proposed amendments, this commission has had a lot of conversation about affordability standards and mixed use in business zones, and those two pieces are not inherent to the state legislation, and so if our zoning regulations do not specify what those standards are, then we wouldn't have the ability to include them if these applications come forward. So the amendments that we're proposing, I'll go through the sections and kind of a very quick overview. So adding definitions, because there are certain definitions that we do not have in our regulations. So in section 3, we would add definitions for cottage cluster, and then middle housing would be broken up into middle housing residential and mixed use middle housing, because the act contemplates both. We would change some provisions in section 10, which is our site plan section. So the site plan is essentially clarifying that the site plan requirements are intended to be used for summary review, so there's no question about process in the future. We would also, this 10.2.3a also just references back and does some belt and suspenders for the newly adopted section 36 stormwater regulations. So it's clear that these are all of these site plan requirements linked back to regulation amendments we just made. In section 12, this is not something that's specifically required by the act, but we did put this into the notice in the proposed amendments. We have a provision in our in section 12.3.3a, which currently restricts or puts provisions on residential unit sizes for apartments and mixed use development. This is a holdover from PA 2129. So in 2021, the towns were reminded that they need to essentially use building code as the minimum unit size, and so we still have some holdovers in our regulations. So this cleans that up. It's not required for the July 1st piece, but it's something that we have to follow anyway, and we've been following since the adoption of that reg. Section 23, transit-oriented development overlay. There are pieces in this total overlay zone that don't comply with middle housing, so we had to go back in and change the text in that regulation. And so it basically clarifies what those pieces are, and that middle housing is specifically permissible. And then if there's any mixed use uses, there is a provision that essentially says, here's how middle housing is permissible in the Toto. If folks are coming in with one middle housing unit per lot in any of the areas in the Totos that may be looked at as mixed use, there's not a change to the Toto zone that would be required, right? Because you can't have special exceptions relative to this. And if it's already slated for residential development, again, there's no need for, sort of a public housing provider, that residential is the only use listed in this total approval and the master plan for that particular area. So as time goes on, the only TODA we have right now, as folks know, is an association with the Unilever development, so we would make sure that we pay attention to this if there's any modifications to the master plan for that development. We would be adding uses to section 27.2, which is this non-resident, or sort of the sort of more commercial section of our regulation and table of permissible uses. Something to think about here in the permitted uses. So middle housing residential, which is exclusively residential buildings, would be allowed in all of the applicable zones, with the exception of the business zones, which is something that the commission wanted to make sure that we preserve mixed use. And again, the act specifies you can permit residential or mixed use, right? It gives you both of those options. And so this reflects the commission's prior discussion on preserving mixed use opportunities in the business districts. And then again, mixed use is permissible throughout, and you'll see that the industrial districts do not include any of the middle housing, because there are no other residential uses currently permitted in them. Therefore, the act does not apply to them. The other piece of this, there is a new section 37, which is where the standards for middle housing are specifically located. So there's a couple pieces here. It identifies, middle housing as a different use than multifamily or mixed use that exists in section 12 and other section 27 portions of our regulations. So it says this is something separate, and we're regulating this as a separate kind of use. It specifies in its purpose that it's being adopted pursuant to Public Act 25-1, so it ties back to that legislation. It does include the affordability component that we have discussed in the past, which is allowed but not required under PA 25-1. So this is the provision where for every 4 dwelling units within a middle housing development, at least one has to be subject to binding recorded deeds that essentially hold for 30 years, that require such units to be sold or rented at or below prices that preserve the units for housing, for which persons and families pay 30% or less of their income. And that income shall be less than or equal to 80% of the median area income for the first affordable unit, and less than or equal to 60% of the median income for the second unit, as defined by Connecticut General Statutes 830G. So we had talked about, when we had our discussions, we had talked about a 30-year affordability period, and that's something that we can chat about in a little bit as well. But that's the language that the commission had previously gone with. And again, there's the affordability plan that's required, and the language in C here to ensure that anything that's deed restricted is comparable to the market rate units, which is a requirement of the statute, but is good to clarify. Other provisions in section 37, it makes sure that any of these developments that may be proposed in the East Main Village District, in the remaining village zone around 145 of the police station, and the Liberty Green Historic District are subject to the requirements of either the ENVD zone and design standards, the village zone standards and the regulations, or have to go, it's clear that they have to go for a certificate of appropriateness in the historic district. 37.7 includes design standards. So these are our lighting, parking requirements, landscaping requirements, provision of sidewalks that connect back to the public way. All of those pieces are included in there. It clarifies that only one middle housing development is allowed per lot. So we're not having, sort of multiples of these. Things like prohibiting parking in the front yards, all those things that we've discussed as sort of priorities for these developments are included in section 37. It also includes the provision, again, that is not required in PA 25-1, but we can put into our standards, where if a mixed use middle housing development is proposed, where the first story in our business districts faces the street, there has to be a commercial use in that space, a non-residential use. And then if there's pieces that don't face the street or sort of on the first floor, that could be residential, but the first floor does need to have that mixed use component to it, and that's where we want it to be. So that's important there. It also provides design standards that separate things like access and parking and those types of pieces for commercial versus residential uses, so that those pieces flow and don't sort of disturb each other. One piece, so we did send this out for review to all of the required, sort of intermunicipal, RiverCog, and DEEP review agencies and authorities. The one piece that came back with the suggestion, so most things were found to be fairly consistent with pieces. We didn't hear back from Madison or Westbrook, but we did, which again, sort of they're contiguous and the zones would and the effect would abut those two municipalities. Didn't hear back from them, but we did hear from Rivercog, who found it to be consistent, which is beneficial since they provided the consulting services and a lot of the support to make this happen. But the other piece was from Deep. Generally speaking, Deep found the language to be consistent with the Connecticut Coastal Management Act, but did suggest this revision that's this in red here. Specifically relating to public health and safety in section 37.8, adding the language at the end so that it would read, no middle housing development shall be approved if it is found to substantially impact public health or safety, especially with respect to increasing residential density in coastal flood hazard zones where dry egress for evacuation and emergency responder access cannot be provided. So essentially what this language would do would shift the burden to the potential developer to prove that they don't have a safety issue relative to dry egress or emergency access during a flood event. So our next steps to think about here include obviously the hearing and public testimony, to consider adoption, and there is a staff recommended effective date of July 10th if the commission chooses to go forward, which would enable us to publish the legal notice and go through our appeal period before the effective date takes is there. And then we'll need to follow up with amendments for the parking districts, and we'll talk a little bit about this postcard question and stuff another time. This is the notice issue, and there's some language in our regulations that we need to make sure that we are very specific about how that notice goes out. So right now, I think we had previously discussed with the commission that going to the July 13th hearing, we will give you an update as we go forward with that. So those are sort of the big picture pieces here. You know, again, the consequence of not adopting this is the sort of slide that I showed earlier of not having something in place or, you know, sort of within its appeal period and intended to be in effect. When it comes time to actually receive an application after July 1. So after July 1, we comply no matter what. The question is, will our regulations catch up?
Thank you. I'd like to start by saying, one of the things that you brought up, the comment on 37.8. I would like to see us consider that as a condition. The other one that comes up is section on lighting, section.
Two sections. I had a question of whether or not, and it's kind of late in the game, so we probably have to revisit it, whether or not we can, instead of having it be affordable for 30 years, have it be permanently affordable.
Did we do that?
Well, that was the question. You know, that was the question. Well, because it's not an 830G though, it's kind of mimicking 830G.
Yeah, it's mimicking.
So it's a question that will have to be answered, and I don't think we can go forward with it, with that idea this evening. I think it has to be answered, perhaps revisited. And my other,
Lighting one.
yeah, the other.
I think we can do it as a condition.
The other one was under 37.7H, which is outdoor lighting, and it says no lighting shall be of such intensity or direction as to create glare on adjacent properties or adjacent streets, highways. All exterior luminaries shall be downcast and full cutoff shields directed inward towards the site and away from oncoming motorists. And should we add that it has to meet the requirements of section 30.3.4, which is our lighting standard, and that has to break it down into foot candles at the border and that sort of thing. And I think that takes away, you know, any gray area that might be there if we just add the reference to 30.3.4.
Anybody had any other
Yes, I had a comment.
condition, but.
My comment was on 37.7 C. It talks about traditional common materials such as brick, stone, and wood. I preferred, hardy plank, or I guess it's called fiber cement generically, is widely used these days. And it's not mentioned in either the preferred or in the thou shalt not section. Do we have did we want to mention, that kind of facade material at all?
You sure, I mean, that's a fair, I mean, it's fairly consistent with the materials that are listed. You're adding to, not taking away, or you're not putting something that's more restrictive into the regs. So I think that would be a permissible amendment if you wanted to make
You
it.
made it permissible, so.
It just, basically allowing 5% flat, like.
So, it's not verification because this takes into effect on July first, then there is a gap since this is not going to come into effect until July 10th. Is that what I'm hearing?
Correct. Typically, when folks go to make application, if the action has been taken by the commission and they know where the commission is headed, unless they're trying to sort of pull something through, and then we would probably get the town attorney involved, most folks are gonna go ahead and comply. And these aren't incredibly onerous standards. So the hope would be that, you know, like most applications, folks come in and it's a partnership. So that's the hope.
Okay.
It would be the July 13th.
Safe meeting too, because then they would have to present under the new
Correct.
regulation.
So it would be received July 13th. You'll be fine.
Right, okay.
Any other questions or comments from the commission before I open it up to the public? Okay, with that, this hearing, as you probably noticed, is being recorded as required by state law. We now have it open to members of the public if they wish to comment on these regulations. We typically take comments from those in favor of the regulation or the item on the agenda first, then those in opposition, then those with general comments. But seeing as we only have two people in the public tonight, I'll let you testify in whatever order you want, assuming you want to testify. If you do, please come closer and speak so we can pick you up and state your name and address for the record.
Sure. My name is Pat Lavadia. I own 29 Knob Road here in Clinton. I live in Westbrook, 36 Orchard Drive, Westbrook, Connecticut. I oppose the amendment. I look at it like this is not a recognition by this board of the public policy that's been established by the state of Connecticut by passing this public act. And that public policy has to deal with the fact that we're in a housing crisis at the present time. There's all kinds of information out there. There is not enough available housing. The prices of the housing has gone up tremendously. And then people start to talk about affordability, but I think that's a trap. I think what you have to do is look at supply and demand. You know, if there are more units available, the prices are going to come down. If there is a limited amount and there are a lot of people that are looking for apartments, naturally the price is going to go up. So the point of the state is that they wanted to try to make this middle housing size more attractive to people who own these properties to be able to develop them in a good way, in an economical, sensible way. And when you think about that, you say, well, listen, if we're going to go back, I heard one of the people before the meeting started saying something, well, this is a way for us to try to keep some control. Well, I think that's contrary to what the state is saying. The state is saying, we want the control. We want you to allow these people to make more apartments available at a reasonable cost so that the prices will start to come down. And that's the way I look at the affordability. So adding an affordability provision to the act, I don't think does any good. I think it's contrary to the state policy. And then I look at it and I say, look at Clinton specifically. I had a law office here in Clinton for 37 years. I still have a little office over behind Chip's Pub. But I've been mainly working at home, out of home since COVID hit. So I meet clients and do business there. But I look at the commercial property that's available just by driving up and down Route 1, and it really is becoming a problem, okay? And there is no demand for that commercial property. So now what we're doing is, instead of encouraging people to develop the property and make them residential, because that's where the demand is, supply and demand again, we're forcing them to take a portion of it and make that property be used for commercial occupancy. So right where my office is now, Chip's Pub in the back, there's an office there that's been empty for probably close to a year now, in the rear corner portion of it. So I look at that, I look at all these other places that are for rent, and I say, this really, it doesn't make sense. It's against common, we have to look at it with a common sense approach. And I say, look, why don't we allow this and not put another roadblock in the way? And then again, going back specifically to Clinton, we just went through a reval here, okay? And I look at this and I say, look, we had a modest increase in our budget. I think it ended up just under 3, maybe just over 3. I don't know exactly. And I look at that 3%, okay, you know what? That everything's going up, I understand it. But when you look at the tax bill, my taxes went up more like 20%. And the reason was that the assessor, when they went through with the reval, assessed residential properties higher because, again, supply and demand, and commercial properties lower. So now, by forcing these people to not allow more residential and forcing them to continue to book commercial there, we're forcing them to devalue their property, basically, because now it's commercial, it's not worth as much. And you know, it's property they already own, and it's impeding their ability to make money and pay their bills. So I'm not here to complain about my tax bill, because you're not the right board to do that to anyway, and I'm not complaining about it anyway. But I'm looking at it and saying, well, what did that do? It made the residential, I rent out the property I mentioned on Knott Road, and that made that property over $1,000 higher in taxes. So now I have a tenant that I've got to go to and say, look, your taxes are probably going to go up about $100 a month, you know, and I don't cherish the fact that I have to do that, but you know, it's unfortunate, and I feel bad for people that are in that situation, that are having a hard time making ends meet. So what I would urge this board to do is look at what the legislators intended, look at what the governor intended in supporting this bill, and not put up more roadblocks, because I think that's what some of these amendments are doing. And I appreciate that Ms. Pearsall was going in and saying, look, we have to be compliant in that portion of it. I totally understand. But the fact that we're putting in an affordability provision, and then we are also adding in a commercial component to it, I don't think is the right decision for this board to make at the present time, under the circumstances that we're being faced with in the town of Clinton today. So I would suggest that we vote no to those portions of the amendment.
Thank you very much.
Thank you.
Is there anyone else who would like to testify? Okay. I'll bring it back to the commission. Does anybody have anything they want to follow up with?
Well,
I will say that I respectfully disagree with the gentleman's testimony. While it does, I understand his point about commercial, we're actually still adding though, because right now, that area requires commercial space, pretty much period. And now we're allowing the additional, residential units in there, and the state also, when they passed 25-1, made provisions for municipalities to have some sense of independence so that we can establish something that works best for the towns, whatever town we're in. And I think that these measures, as outlined here, keep it consistent with our plan of conservation and development while also being consistent with 25.1.
And
It strikes a balance.
I have to agree with that, point of it. Fitting the plan of conservation and development. Because that, we just finished that last year and the changes those provisions all stem from the P O C D.
Yeah.
I would also like to make a point that, Shenzi just pointed out that we're going to have a 10-day gap. No matter what, this is the option that's on the table for us to have a regulation in place, and it just the state default. We do have, the plans to do a pretty major revamp of the regs in the next year. And that will all be open for commentary and input at that time if people want to come forward. But I think it would be very irresponsible not to give ourselves, the noticed available regulation taking effect on the 10th of July.
Any other comment?
With the changes that have been discussed so far.
Cindy?
Just want to talk about the affordable component for 37.4 for the affordability requirement. So for the middle housing, so that would, the 30% would only take place if there's 4 dwellings.
Correct.
So it has to be a minimum of 4 for that 30% to kick in. Otherwise, it's still the 60 or 80%, which is very similar.
Once you have 4 dwellings, then you have to have one of those dwellings has to be an affordable unit.
Right,
The 30% just goes back to the kind of the outline in 830G of what the
right.
income. How they consider the income.
That is, if somebody earns 80% of the average income, then they cannot be required, they can be required to pay only 30% of that 80% as their rent. And then the second unit, they're required, to pay.
But that would mean
60%.
There would have to be 9 units for that to also then kick in. It's every 4. So I just wanted to clarify, it's every, 8. Yes,
But it's 30% of whatever the other percent.
Right.
gotcha. Okay. So if it's less than the 4, it still is.
Right.
Right, so if middle housing is 2 to 9
But I'm
units,
just saying,
if it's 2 units or 3 units, there's not a
Right.
requirement.
Okay, so that's, I just wanted to make that
12, you're not middle housing.
correct, right, I just wanted to make clear that you have to actually hit the 4 first. for
Yes.
that part. Okay, so anything less than that? Okay,
Okay. Any other discussion from the commission? With that, I would entertain a motion to close the public hearing.
So moved.
one other question, are there any, I know we've talked about this before, but would there be any, opportunities for special exceptions under this?
No,
No.
because a special exception requires, it's a discretionary process, it requires a public hearing. These middle housing developments have to be by law approved by summary review.
And we're declining.
that.
So the middle housing developments have to be by Public Act 25-1, have to be approved by summary review, and one of the amendments in section 10 that's proposed tonight is to define summary review as our site plan process, so it clarifies that, so it is a site.
So
plan.
it wouldn't go to public
There
hearing.
is no public hearing.
It's, again, at a much lower standard.
Again, we don't have choice on that. That's the state statute. The choice we have to back with the legislature.
We have a motion, is there a second? Oh, second. Strange committee. Okay, all those, in favor?
We're voting to close.
Closing
here.
the public hearing.
Aye.
Opposed? Same, motion carried, thank you. The next item, because, we're skipping, 26-14 because we had the notice issue. Is staff reports, which we've already heard, so now it's, we are, ready to discuss and, consider, voting on, 26-13, the text amendments, related to middle housing.
So I do have when you're ready, a draft motion for you, and then I took some notes on the comments that you had during the public hearing, so once you're ready for it.
Okay. So is there any discussion that people would like to have on this?
I think the three, just to go over the
Go
three
ahead.
comments would be the deep suggestion. The reference to our lighting schedule and also the reference to the composite materials. Yeah.
Don't cause them hard to.
So then all those are technically amended through this, then we're adding the,
We can add those.
okay,
And I have some language written that I can read for you.
okay.
Yes. With those three changes, is there any, other discussion that people have? In that case, could you, those two?
So the proposed motion includes the change to 37.8 relative to the safety issue and Deep's comments. The other pieces that I looked at adding based on your conversation tonight was, so that one would be number one, section 38.7.8 shall read, no middle housing development shall be approved if it is found to be substantially impact public health or safety, especially with respect to increasing residential density in coastal flood hazard zones, where dry egress for evacuation and emergency responder access cannot be provided. Number two would be to amend section 37.7C to include fiber cement plank as one of the preferred listed building materials. And number three would be to amend section 37.7H to reference that the lighting plan shall be compliant with section 30.3.4.
So.
I'm prepared to make a motion.
You're prepared to make a motion? Okay.
I move to amend sections 3, 10, 12.3, 23, 27.2, and to add section 37, middle housing, to the Clinton zoning regulations as drafted in PZC 2613 with the changes that we proposed this evening. Section 37.8 shall read, no middle housing development shall be approved if it is found to substantially impact public health or safety, especially with respect to increased residential density in coastal flood hazard zones where dry egress for evacuation and emergency responder access cannot be provided. Do we have to list the others?
Mhm.
Yeah. We're going to amend.
What was the other section?
Two is to amend section 37, the proposed section 37.7C, to include fiber cement plank as one of the preferred building materials.
To amend to include
7C,
7C to include
Fibers.
cement plank.
fiber cement planks. And then to add to 37.7H that the outdoor lighting must meet the requirements of section 30.3.4. This motion should have an effective date of July 10, 2026, and adopt the following findings of fact. Public hearing for the proposed amendments to the Clinton zoning regulations met the notice requirements in TGS 8-7D. The proposed text is adopted pursuant to requirements of Public Act 25-1. The proposed amendments are consistent with section 1.4 purpose of the Clinton zoning regulations and Connecticut General Statutes 8-2. Proposed amendments are consistent with the 2025 Plan of Conservation and Development's goals to promote housing diversity, The proposed regulations as amended are consistent with the purpose and requirements of Connecticut's Coastal Management Act.
We have a second?
A second.
Oh,
You want to second it too? I can say I'm sorry.
Any further discussion? With that, all those in favor, opposed? And the motion carries. Thank you very much. We don't have, again, 26-14, so the next item is adjournment.
Make a motion to adjourn.
Okay,
I think before we adjourn, I'd like to thank Eddie Alvarino for his service to the town of Clinton, both on this commission and the other boards and.
Yeah. I
areas.
appreciate it. I really enjoyed being there and it's been a lot of years, so a long time. So thank you very much.
Thank you.
And I hope my future endeavors with hospice are not good, but thank you very much. I appreciate everything.
All those in favor?
Aye.
Opposed? Thanks, motion carries. We're adjourned at 7:41.